It is up to both parties to the contract to disclose material facts related to financial hardships. It is also up to the listing agent to make sure that they are marketing the property correctly in MLS. If the 90-day rule applies, if it is a VA-approved community, etc. Agent must disclose material financing facts in listing. Facts. A condominium was listed for sale on the Multiple Listing Service, MLS. The listing shows the seller will accept conventional financing or cash offers. Ultimately, the buyer's lender discovers that a conventional loan cannot be approved for the condominium because too many of the units are owned by one owner. The buyer ultimately pays cash, and the transaction closes. 1 month later, the buyer's agent sees another condominium listed on the MLS by the same agent accepting conventional financing. Issue. Does the listing agent have a duty to disclose that the condominium cannot qualify for conventional financing? Answer: yes. Discussion. Pursuant to the Arizona Administrative Code, R428-1101, an agent must disclose all known material facts regarding a property. Additionally, R428-502C states that a salesperson or broker shall ensure that all advertising contains accurate claims and representations and fully states factual material relating to the information advertised. A salesperson or broker shall not misrepresent the facts or create misleading impressions. However, the buyer's agent shouldn't assume that all conventional loans are prohibited on this property. Therefore, as a best business practice, the listing agent should disclose that the condominium may not qualify for all conventional loans and that the buyer should investigate their financing options during the inspection period. Material facts related to financial hardship. For the seller. Short sale situation. If the seller's sale is contingent on lender approval because they owe more than the property is worth, that must be disclosed. Foreclosure or pre-foreclosure. If the seller is in foreclosure, received a notice of trustee's sale, or is otherwise in a legal process of losing the property, that must be disclosed. Bankruptcy. If the seller has filed for bankruptcy and it affects their ability to close the sale, this must also be disclosed because it materially affects the transaction. For the buyer. Contingent financing risks. If the buyer's ability to perform, close the deal, is contingent on selling another property, or if the buyer has known financing difficulties that could threaten closing, that should be disclosed to the seller if it becomes material. Bankruptcy or legal restrictions. If the buyer is in bankruptcy or has legal limits that could prevent performance under the contract, they should disclose that. Fraudulent intent or inability to perform. If a buyer knows they cannot obtain financing and still proceeds as though they can, it could be fraud. Material facts about their financial ability must be disclosed if it affects the transaction. Bottom line. Financial issues that could delay, derail, or materially affect the transaction must be disclosed. Both sides have a duty to be honest if known hardships could impact closing. Bankruptcy requires court approval for the sale of real estate when the property is part of the bankruptcy estate. Specifically, if the seller is in an active bankruptcy, Chapter 7, Chapter 11, or Chapter 13, and the property has not been abandoned by the bankruptcy trustee or court, then court approval is needed to sell it. Chapter 7. The bankruptcy trustee controls the assets. The trustee, not the homeowner, must get court approval to sell. Chapter 7. Bankruptcy is often called liquidation bankruptcy because it involves selling a debtor's non-exempt assets to pay off creditors. In a Chapter 7 case, a court-appointed trustee takes control of the debtor's assets, sells anything that isn't protected by exemption laws, and distributes the proceeds to creditors. Most remaining debts are then discharged, meaning the debtor is no longer legally required to pay them. Chapter 7 is typically used by individuals or businesses who have limited income and overwhelming debt, and it allows for a fresh financial start, although it can mean losing property. If a homeowner is in Chapter 7 and the home is part of the bankruptcy estate, Court approval is required before it can be sold. OSE. Chapter 13. The homeowner usually remains in control, but still must get court approval to sell any real property. Chapter 13. Bankruptcy is a type of bankruptcy that allows individuals with regular income to reorganize their debts and create a manageable repayment plan, usually lasting 3 to 5 years. Unlike Chapter 7, which involves liquidating assets to pay creditors. Chapter 13 lets debtors keep their property, including their home, while catching up on missed mortgage payments, car loans, and other debts through scheduled installments. The debtor submits a proposed repayment plan to the court, and once approved by a judge, they must make consistent payments to a bankruptcy trustee who then distributes the funds to creditors. This form of bankruptcy is often called a wage earner's plan because it's designed for people who have enough income to pay back at least part of what they owe over time, rather than wiping out debts entirely. Chapter 11. Business reorganizations or high-debt individuals. Court approval is also needed. Chapter 11. Bankruptcy is a type of bankruptcy mainly used by businesses, corporations, or individuals with very large debts and assets who need to reorganize their financial obligations while continuing operations. Instead of liquidating assets to pay creditors immediately, like in Chapter 7, Chapter 11 allows the debtor to propose a reorganization plan to restructure debts, renegotiate leases or contracts, and create a path toward financial stability over time. The debtor usually remains in control of their business as a debtor in possession, but major decisions, like selling real estate or incurring new debt, must be approved by the bankruptcy court. Chapter 11 is complex, often lengthy, and can be expensive, but it provides flexibility for businesses and high-debt individuals who have a chance to recover and move forward. The main difference between Chapter 7, Chapter 11, and Chapter 13 bankruptcy lies in how debts are handled and who typically uses each type. Chapter 7 is known as liquidation bankruptcy. It involves selling, liquidating, a debtor's non-exempt assets to pay off creditors, and any remaining eligible debts are discharged. It's usually used by individuals with little income or overwhelming debt. Chapter 11 is primarily used by businesses and sometimes very high net worth individuals to reorganize debts and keep the business running while repaying creditors under a court-approved plan. Chapter 13 is a reorganization bankruptcy for individuals with steady income, allowing them to keep their assets while repaying debts over 3 to 5 years through a structured payment plan. Essentially, Chapter 7 erases debt quickly. Chapter 11 restructures debt mainly for businesses, and Chapter 13 restructures debt for individuals who can afford to pay some, but not all, of what they owe. Key tip for real estate agents: always ask if the seller is in active bankruptcy. Always confirm whether the court trustee has authorized the sale before proceeding to close. The authorization comes as a motion to sell approved by the bankruptcy judge. Summary: active bankruptcy, court approval required to sell the property. Special commissioner process for real estate agents in a bankruptcy situation. When a property owner is in bankruptcy, especially Chapter 7 or Chapter 13, court approval is often needed to sell the property. A special commissioner may be appointed by the bankruptcy court to assist with the sale. Here's how the process typically affects real estate agents. Appointment of special commissioner. The bankruptcy court appoints a special commissioner, often an experienced real estate agent, attorney, or broker, to have authority to list, market, and sell the property under the court's supervision. Agent's role with the special commissioner. If you are the agent representing the seller, the debtor, or the bankruptcy trustee, you must coordinate closely with the special commissioner. You cannot proceed with listing, marketing, or selling the property without the special commissioner's approval and ultimately the court's approval. Court orders and listing agreements. The special commissioner must often petition the bankruptcy court for permission to hire a listing agent, you, and approve the listing agreement. the listing agreement and the commission amount must usually be filed with the court and approved in advance. Disclosure to buyers. The MLS listing and buyer communications must clearly disclose that the sale is subject to bankruptcy court approval. Buyers must understand that any offers accepted are still contingent on court confirmation, which can take extra time. Handling offers. When you receive an offer, the special commissioner reviews it and submits it to the court for approval. Sometimes, the court may even order an auction if it believes it could get better terms. Compensation. Your commission is subject to court approval. Even if it's agreed upon in your listing agreement, you don't get paid until the court signs off. Quick summary for agents. Work closely with the special commissioner. Expect delays while waiting for court approvals. Disclose the bankruptcy situation upfront to buyers. Know your commission isn't guaranteed until the court approves it. ADRI, Arizona Department of Real Estate, rules definitely affect how agents must handle bankruptcy situations, mainly through general disclosure, advertising, and honesty requirements. There isn't a separate bankruptcy-specific rule, but several existing ADRI rules apply to bankruptcy sales. Here's the key. Arizona Administrative Code, AAC, R4 28 11001, Duties to Client. Agents must disclose all known material facts that could affect the buyer's or seller's decision. Bankruptcy, sellers or buyers, is a material fact if it impacts the ability to close or conditions of the sale, like needing court approval. AAC R4 28 502C. Advertising standards. All advertising, including MLS listings, must be truthful, accurate, and not misleading. If a property is subject to bankruptcy court approval, this must be clearly disclosed in marketing. Otherwise, it's misleading. AAC R4 28 1101K. Disclosure about ability to perform. Agents must disclose anything they know about a party's ability to complete the transaction. If the seller's bankruptcy could delay or prevent closing without court approval, the agent must disclose that fact. There have been court cases involving buyers who are going through bankruptcy and how that affects their real estate transactions. Below are a few key examples of how bankruptcy can impact buyers, their ability to purchase property, and the legal responsibilities of both the buyer and seller during the transaction process. 1. In REFC and LC bankruptcy court case. Case overview. In this case, the buyers were in a Chapter 13 bankruptcy. They had entered into a real estate contract to purchase a home, but the seller sought to void the sale, claiming that the buyer's bankruptcy would prevent the completion of the sale. The buyers were unable to obtain court approval for the sale without modifying their bankruptcy plan. Court ruling. The court ruled that the bankruptcy trustee must approve the purchase and that the seller could not cancel the contract solely because the buyers were in bankruptcy. The buyer's ability to close was contingent on the bankruptcy court's approval, and the seller could not block the transaction based on the bankruptcy status alone. Impact. This case demonstrates how a buyer in bankruptcy may still go through with a real estate transaction, but the transaction may be contingent upon bankruptcy court approval. 2. In RE-JAM bankruptcy court case. Case overview. A buyer filed for bankruptcy under Chapter 7 and attempted to purchase property during the bankruptcy proceedings. The seller's agent did not properly disclose that the buyer's purchase would require bankruptcy court approval, and the transaction proceeded without such approval. Court ruling. The court ruled that the sale was not valid because the buyer's Chapter 7 bankruptcy required court approval to sell any property or enter into any contracts that would affect their assets, including real estate. As the buyer did not seek approval for the transaction from the bankruptcy court, the contract was invalid. Impact. This case highlights that in a Chapter 7 bankruptcy, court approval is required for any sale of property, and failure to obtain approval can render the transaction void. 3. In RE-WM and CM bankruptcy court case. Case overview. A buyer was in Chapter 13 bankruptcy proceedings, but had entered into a purchase agreement with the seller. The bankruptcy trustee objected to the sale, claiming that the buyer's current debt repayment plan was jeopardized by the property purchase. Court ruling. The court ruled that the trustee had the authority to object to the sale based on the potential effect it would have on the buyer's ability to repay debts. The court ultimately ruled that the sale could not proceed without modifications to the buyer's repayment plan. Impact. This case illustrates that a buyer in Chapter 13 bankruptcy must consider how any real estate purchase might affect their existing debt repayment plan and obtain approval from both the bankruptcy trustee and court to complete the transaction. 4. In a RM bankruptcy court case. Case overview. In this case, the buyer entered into a contract to purchase a home but failed to disclose that they were undergoing Chapter 11 bankruptcy proceedings. The seller, upon discovering this, raised concerns about the buyer's ability to close the deal, as the bankruptcy had not been disclosed. Court ruling. The court ruled that the buyer's bankruptcy status must be disclosed to the seller. The buyer was required to provide full transparency about the bankruptcy to ensure that both parties could properly evaluate the impact on the transaction. The court also emphasized the importance of bankruptcy court approval. Impact. This case underscores the importance of transparency when dealing with real estate transactions and bankruptcy. Full disclosure of bankruptcy status is necessary to avoid issues in closing the deal. Key takeaways for real estate professionals. Bankruptcy court approval. In Chapter 7 and Chapter 11 bankruptcy cases, court approval is almost always required for the sale of property. Disclosures. Buyers in bankruptcy must disclose their status, especially when it could impact the ability to close the deal. Failing to do so could invalidate the transaction. Impact on ability to perform. Bankruptcy can affect the buyer's ability to perform under the contract, so agents should always confirm whether court approval is needed before proceeding. Practical tips for agents. Always ask if the buyer is in bankruptcy and understand which chapter of bankruptcy they are under, 7, 11, or 13. Ensure proper disclosures are made if the buyer's bankruptcy could impact the transaction. This might involve disclosing the need for court approval or advising the seller of any risks involved. Work closely with bankruptcy trustees to ensure that all approvals are obtained before moving forward with the transaction.